Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. Hello, lovely people. Another Saturday afternoon is here with us, and we're so grateful to the Almighty for giving us life, and also so happy to come your way with another edition of The Community and the Law. The topic this afternoon, very interesting, and I want you to pay particular attention because as I'll pose a question along the line, is it A or B? You might be tricked into saying is A, probably B, but I'll tell you which the correct answer is. Can a sperm donor claim paternity right and also rely on the child to remain in the UK as a parent? Very interesting over there. Lawyer Charles Asma is right here with us to help us look at what the law says, what the official position is, and what you can do and what you cannot do. Are you ready? I invite you to join us live on the program, The Community and the Law, brought to you by BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
It's always a pleasure to have you around when we come on the program, The Community and the Law. It happens every Saturday afternoon between 4 p.m. and 6 p.m. UK time. My name is Oriku Frimpon, and on behalf of the team and crew, I welcome you to another edition of the program. And it's always brought to you by courtesy of BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors is a law firm that helps us to put in our applications for various immigration issues, nationality, family, and of course, we're talking about marriages and divorces, business support, and business development advice. And again, representing us every aspect of the law. And we would want you to come visit us on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. We work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call us and book an appointment. Come see us on 0208 493 7340. The number again, 0208 493 7340. You can also call on 077 127 61884. That's a mobile number, and you can call at all times in all situations, especially in emergency situations. You can send in a text or WhatsApp to the same number, 077 127 61884. So BWF Solicitors, thank you so very much. And those of you out there who have just joined us, we are live on Facebook and YouTube at BWF Solicitors and at BWTV. So when you join us, announce yourself, like the page, share the link with your compatriots, your family members, people in your network. Ask them to subscribe to the channel and click on the notification button so that whenever we put out content, you will be notified. Remember, is at BWF Solicitors both on Facebook and YouTube, and at BWTV, both Facebook and YouTube. Well, BWF Solicitors helps us to understand several aspects of the law and also empower us so we can understand what it is that we are doing, what it is that they're doing for us, and what it is that the law says. And at the beginning of the week, they put out the nugget where it is that we look at some aspects of the law that we probably have to pay attention to. And then when we come on the program, they help us unravel that. And this afternoon, we're looking at the landmark UK fertility law decision. In REN 2026, England and Wales High Court case 878, Family Division, the High Court refused to recognize an unregulated sperm donor as the legal father of a child, even though DNA confirmed he was the biological parent. The case actually involved a private sperm donation arrangement outside a licensed fertility clinic. The court held that legal parenthood is not determined by genetics alone, and that recognizing the donor as a legal parent would undermine UK fertility law, designed to regulate sperm donation and protect children and families. The decision is an important reminder that private fertility and donor arrangements can have serious legal consequences. So I would want to add that at BWF Solicitors, they gave advice to families on complex family law, immigration, British nationality, parental responsibility, and international surrogacy matters. So our topic this afternoon obviously falls within what they do and do very well. And with that, I would want to do the housekeeping and welcome our resource person for the afternoon. He's from the stables of BWF Solicitors, so you trust that there's going to be some very cogent discussions here. And he is in the person of lawyer Charles Asma. Uncle Charles, good afternoon.
Good afternoon, Michael.
Thank you very much for giving us your Saturday afternoon once again. We really appreciate that. And I would want to say on behalf of all our listeners, the clients, and our viewers, we don't take it for granted. Thank you.
Pleasure.
Right. And this afternoon, you have really selected a topic that would tickle the fancy of people, get our minds set to do some critical thinking, and then also take us through the law. It's an interesting one. I tell you, the interest is so high out there. Yeah.
Good. Yeah, I mean, so we will be looking at the interplay between sociology and law.
Okay.
Because law itself is social science.
All right.
Sociology deals with human beings, human behavior, what is good, what is wrong, and that shapes how things ought to be in the future.
Mm-hmm.
And so before a judge would decide A or B, a judge would have put himself or herself in the shoe of a human being living in a community, which is society, and what consequence that decision will have for that community or society of which he, the judge, or she, the judge, is a part of.
Well, but let me ask this very interesting question. Now, when it comes to social values, some unwritten protocols within the community, would that be able to override what the law says?
So we have what we call public good.
Mm-hmm.
Public good is anything that is good for society.
Right.
And anything that is not so good, the society would want to frown upon that. And so judges will want to uphold what is right and wrong within society.
Okay.
And if it is not going to affect social cohesion, it's not going to affect family values, then the judge would always want to uphold the law itself.
Mm-hmm. Right.
So the question is, will a judge always uphold the law against common sense?
Right.
Or the other way, where where the law and the common sense are at odds, the judge will always go by the side or with the side of the common sense.
Okay.
I've said so much.
Yeah, I know. Yeah, our discussion obviously would bring those things out quite well, because I'll ask the question: what is rightly mine is rightly mine.
Yes.
Why would the law take it away from me? And if I go to court, would the judge side or play on the side of common sense rather than the law?
You know, in medicine, there are instances where a doctor will tell you, for this medication, you eat before you take.
Mm-hmm.
Another time, the doctor will say, for this medication, you take before you eat.
Mm-hmm.
Have you wondered why? If the belly is empty, that is when the medicine will work. So I have to be hungry before I eat, before I take the medicine. There are others that go well or works well with
there's food.
With food.
Mm-hmm.
And so the doctor will tell you, you've got to make sure that you have food in the belly.
Mm-hmm.
Why all these nuances?
Okay.
And if we relate it to the law, social values, sociology, common sense, the interplay, where do we place it? Especially where we are looking at people who are kind to help people to procreate, reproduction,
mm-hmm.
where they cannot do it themselves and they can assist. That is what kindness is all about. But in an attempt to show kindness, is going to undermine integrity of the community itself, then that kindness will be taken away.
Well, we'll be coming really into that. But I want to bring up the nugget again, what the law is saying about fertility in the community. And it's saying that in that case of REN 2026, which is it's quite new of the block, and it's saying that the court refused to recognize an unregulated sperm donor as a legal father of a child, even though DNA confirmed he was the biological parent. It involved this private sperm donation arrangement outside a licensed fertility clinic. The court made its stance known and held that legal parenthood is not determined by genetics alone, and that recognizing the donor as a legal parent would undermine UK fertility laws designed to regulate sperm donation and protect children and families. I'm bringing it back to you, even though I've put you straight into the deep end anyway. Bringing it back to you, this nugget you put out obviously underpins what we're going to discuss. But the law is saying that yes, you have made an arrangement, you've gone into your private arrangement and had an issue out of that, but within the community, I can't accept it because it would do some damage to the general good of the community. But what is mine? It's mine. That's what I'm saying. So maybe you would want to take us through this critically, so then I can get my understanding of what it is. Because I don't get it. My sperm is my sperm. I give it, and a child is brought out of it.
I agree.
Yes.
And you can see that we'll go to the case itself. Producer, please get a case ready. The case of Ray N. 2006. Get it ready. We'll be going into that.
Right.
Why the judge disagreed, even though agreed.
Okay.
No, the judge agreed and later said, I disagree to give you your right. So the judge first recognized the right. No, later on, please. Back to the nugget. So the judge first recognized the right of the person within the rules and said that no, for the sanctity of society and upholding social norms and values, I will take that right away from you.
Okay.
And if you look, as you read, it says the second part of the second paragraph, the second part of the second paragraph, it said the court held that legal parenthood is not determined by genetics alone, and that recognizing the donor as the legal parent would undermine UK fertility laws designed to regulate sperm donation. Those laws designed to regulate sperm donation looks at the interest of the child that is conceived out of such sperm donated, the interest of the donor, that is the person giving the sperm, and the interest of the donee, the person receiving the sperm, and also any other third-party beneficiaries. So we are looking at four parties here. The man giving the sperm, the donor, the lady receiving the sperm, the donee, the child being born out of the sperm, the center of it all, and the third parties who may be benefiting from that child, i.e. the mother's husband, who needed somebody's sperm to be donated for him to become a father. So there are four parties here. And today's conversation will be looking at where do we place the right of these two men as far as paternity of the child is concerned. And and that is where the judge said that ordinarily we'll go by the DNA. Ordinarily we'll do ABC. However, in doing that, if it's going to affect the child in question, then we don't have to uphold the right of the donor. And again, the judge looks at what the processes were and whether the processes were followed or not. If the processes are followed, then presumption is that the donee and the third-party beneficiary will be the owners. But if the rules are not followed, then both the donee and the donor are wrong within the rules. And so there will be no equity to favor any of them. And the law will prevail upon the process to decide whether the donor should have a say or the final laugh, or the donee will have the final laugh. If I say donee, again, we attach the third-party man to the donee, because the donee is the woman, and the woman will always be a mother. However, the third-party husband or boyfriend of the woman who needed the donor to be a father in this whole conversation.
All right. So obviously there is the arrangement that is recognized by law, and there is an arrangement that you could do and think that you're doing on your own. We will be unpicking all these things and we'll be looking at what the position is when it comes to those things. But then I'll ask you the question: if somebody is facing a situation like that, what would they do? I have Bola and Bisi's situation, which I'll be coming back to. But lawyer, let me come back to you. If we have that arrangement that is recognized by law, if I don't follow it, I've gone against the law, and it may go against me. In situations where people, for instance, they go into a one-night stand, if I'm allowed to use that expression, and they have an issue out of that, could we look at it and say that, well, you're not legally married, so the child may not be yours because you didn't use the right arrangement. You haven't properly contracted marriage.
Well, we don't have babies only through marriage.
Okay.
We have babies by operation of biology, where the egg and the sperm meet and the baby comes out or is conceived or formed.
Yeah.
That's the standard practice. As to the moral side of it, whether they were married or not married, that's a different conversation. What made them meet is not the conversation for that, and therefore we will not be looking at the married, whether they were married or whether they were not married. We are interested in the conception process.
Okay.
And the conception process, and again, the judge in this nugget took the right of the donor away. But the public must understand, otherwise we will end up confusing the public when we come to the immigration side of things, and especially the quiz. Now, producer, if you could assist us with the ruling and what the judge said, key things that we will pick, and why the judge concluded that the right of the donor cannot be protected, on this occasion. And so, so this is a case in April. The ruling is just this April 2026. And whenever you see abbreviation there like the N, it tells you that it's a case to do with children. So there's protection of identity.
The identity of the child.
Yes.
Okay.
And Ray normally is just according to do that. This is normally family cases or what we call trust and equity cases. But let's go down straight to the judgment. But so I think just for the benefit of the factual background, so the fact, so stay there. So the factual background, this guy, actually the guy's name is given. The abbreviations are there, but the guy's name was actually given. So we have EF, and whose identity has been protected. We have Mr. Albon. Mr. Albon, we are told, is the person giving the sperm, right?
Okay.
Conducted some research and identified Mr. Albon as what? Public sperm donor. So Mr. Albon is that person who says that, me, I have 1 million sperms. I can give you any amount you want. He's a sperm donor. So he goes about distributing, and sometimes he will take a token from people, sometimes he will do it for free, or regardless. And the judge, upon research, finding out the background of this person actually created a social media handle where he would sell his service and all that. And the findings were that he had actually fathered close to 200 children. And this is where public good comes in. Now the judge says that if you're a father to about 200 children, and we conclude that you are the father of all these children, what does it mean? It means all these 200 children are siblings. And imagine all these siblings that we don't even know where they are living. They are going to be meeting their siblings, go into relationships, have babies and all that.
And that's against a lot of moral.
We are told that out of sight
is out of mind.
Exactly. If we don't know, we don't know. But the moment we know that all these 200 children are siblings, it calls morality into question, right?
Yeah.
Hang on. Yeah. And if you judge agree that all these are siblings, and we don't even know where they are, so that we go and tell them, be careful with your brother, be careful with your sister. So the judge said that no, it cannot be, simply because of your behavior.
Right.
Because you've been going, frolicking, and doing this. And so we cannot uphold your behavior. Not that the law is wrong, but
for the public good.
For the public good, you cannot be the father.
Okay.
And what is the public good? He goes to say that I want a declaration within Section 55A of the Family Law Act of 1986 that I am the father of this child. Could be that he's upset with the person and all that. Say, you know what, I will take my baby away. I won't help you anymore. Or maybe the baby is destined to be big person in society, so I have to take up ownership before it's too late. Could be any reason. But why he did that, we are not interested. We are interested in what happened to what he sought to get
from the court. Yeah.
And the court said that your declaration is on point because under Section 55A, small a, of Family Law Act of 1986, you can seek a declaration to be determined as father of the child. And in doing so, we want to see whether the sperm donation process was followed.
Okay.
Because under the Human Fertilization and Embryology Authority procedures, it says that if you want to donate, there is a process to follow. Both the donor and donee must comply. So if both the donor and donee don't comply, then the process is invalid. And if it is not valid, the protection that the donee and the third-party beneficiaries have in terms of ownership over the child will be taken away.
Okay.
Because they didn't do the right thing themselves. And so the judge looked at all that and said that ordinarily you are the father. Ordinarily we must give you that declaration or order that you are the father. However, because of your behavior, what you do and all that, it appears that you are just playing games with the public. And if we continue, if we give you that right, we are more or less endorsing your wrongdoing. And on that basis, we won't give you the declaration. So the ruling is that he didn't get what he sought. Not because he didn't qualify, but because there was interplay of law and common sense. And common sense prevailed on this occasion in the interest of all those children involved in this equation. Imagine there's only one child involved. Do you think the judge would have said no?
There wouldn't be too many siblings.
Exactly. There wouldn't be danger to prevent. And so the judge ordinarily would have followed the law and would stick to the letter and spirit of the law. But because of the dangers associated with this judgment, if the law is upheld, the judge concluded that no. If we are to go by the law, that would be dangerous to society. And so on this occasion, we bend the rule and let common sense prevail so that it will serve as deterrent to people who go frolicking about and coming back to claim ownership of babies.
Well, we will be looking at the consequence of this ruling and how it affects people's immigration status here in the UK. If you just joined us, you're live on BWTV, and the program is The Community and the Law. And it's brought to you by BWF Solicitors, our trusted partners when it comes to the law. We're looking at this very interesting question. Can a sperm donor claim paternity right and rely on the child to actually remain here in the UK? We'll be looking at that in the second part of our discussion. But those of you who have really joined us and have been putting in your comments, we want to once again welcome you and want to also join us to say thank you to BWF Solicitors. Well, a few of the comments we have had, let's see if we can pick them up. I see that Ade Safu is saying that it's a very interesting topic. Nanaya comes up to say good afternoon to all. Thank you very much, Nanaya, for saying hi to us. Collins Kuju, watching you live. Collins, where are you watching us from? If you let us know, that would also be great. Thank you very much for doing so as well. The next one we have is a comment from Ade Safu. Please share when you join. Thank you very much, Ade, for helping us with that. The next one we have, well, keep them coming through. I believe that you would have a question to put to Lawyer Charles Asma later on, and it could be about the topic we're discussing, or it could be anything in the realms of law that you want to put to him, especially when it comes to immigration matters. You can also join us when the lines are active. We will activate them and let you know. 0208-493-7345. That will come to us in the studio. Lawyer Asma is here, and he will pick up your calls and answer them. Or you can send a text or WhatsApp to 07399 208 468, yes, and we will pick that one up. And also, you can leave your comments in the comment section down below, on Facebook at BWF Solicitors, on YouTube at BWF Solicitors, and also at BWTV. BWF Solicitors, thank you very much. After this break, we'll come back and go back into the discussion. What I want to find out is the fertility and the sperm donation law, or the regulations around it. How is it? What do we need to know? And then what would make us operate outside of the law that will make it illegal? Then we'll come back to this particular scenario we're looking at, where a sperm donor would want to claim paternity right and rely on this child to remain in the UK as a parent. Is it possible? Based on that ruling, is it possible? Ordinarily, and as a layperson, I'll say, yeah, why should it not be possible? Because I'm in a situation, I'm in a corner. Why not? The law will tell us whether it's possible or not. And Lawyer Asma is here to do that. So BWF Solicitors, thank you very much. We'll take your message.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Lovely discussion going on, and I know you guys are doing that in the background and asking the various questions. But listen, the experts are here. BWF Solicitors would help us digest the law and also let us in on what we are allowed to do and what we are not allowed to do, and what it is that your situation would allow you to do and also prevent you from doing. Now, this afternoon, as we mentioned, we're looking at a very interesting discussion on the community and the law, and we're asking the question, can a sperm donor claim paternity right and rely on the child to remain in the UK as a parent? Two aspects to it, the immigration aspect and the nationality aspect. We'll come to that. But let's look at actually what the law is saying. Lawyer Charles Asma, as I mentioned, is from BWF Solicitors, is here helping us do that. Lawyer, let me come to you again. And what does the law allow when it comes to paternity and also, let me put it this way, in the ordinary person's language, in making babies? What does the law allow?
All right. So within the manufacturing setup, baby making is biological.
Mm.
What it means is that it takes the egg and the sperm to collide for there to be conception. There are instances where people may not be able to do it naturally by way of intercourse. And so somebody can donate their sperm. Now, we also know that if somebody is offering the sperm, it might be on behalf of somebody who may not be able to produce the sperm themselves.
Mm.
So if somebody has low sperm count, then doctors will advise the person to opt for someone who may be able to donate their sperm on their behalf or for their benefit. So because of controversies as to the right of all these people, the person donating the sperm, the person receiving the sperm, other beneficiaries such as the husband or partner of the woman receiving the sperm, the UK government set up what we call Human Fertilization and Embryology Authority, HFEA, Human Fertilization and Embryology Authority.
Okay.
What the authority seeks to do is to regulate sperm donation process, to protect the right of the donor and the right of the donee and the third party beneficiaries.
Okay.
So on the screen here, we have the Human Fertilization and Embryology Authority that is set up. But there is government backing underpinning the authority.
Okay.
And the government backing, if you go to the .gov website, producer, if you flip, yes. So the .gov website will give advice to people, those donating especially, that if you are kind enough, don't show kindness and regret.
Okay.
That is my way of
putting it. Yeah.
But this is what the government advice says. Producer, go to advice to legal advice to donors. Legal rights. That bit. Legal right for egg and sperm what? Donors. Legal advice. So you are warned, you are advised, you are cautioned. So you don't say I didn't know.
Okay.
And the government tells people people to be aware. And what does the government say? Rako could take us through.
So this one says that sperm donors, if you donate sperm through a Human Fertilization and Embryology Authority licensed clinic, you will not be the legal parent of any child born. You will not have any legal obligation to any child born. You will not have any rights over how the child will be brought up. You will not be asked to support the child financially. And you will not be named on the birth certificate.
Full stop. Now, because today's conversation about sperm donation, we are not even going to the realm of the egg.
Okay.
So we're only sticking to the realm of the sperm. Now, it says that these are restrictions. And these restrictions take away the right of the donor. What is the right of a father? The right of a father is to have his or her name, well, these days we can even have his or her, but let's put that aside, those people, is to have his name appearing on the birth certificate as the father.
Okay.
Ordinarily. Then again, the right of the father is to be able to say that this is my child. The duty of the father is to look after the child. The duty of the father is to ensure that the child is brought up in in the way necessary for growth and development.
Okay.
So we have rights and duties. So if you are a father, you have rights and you have some obligations. The donor, and here we are going to qualify the donor, proper donor. A proper donor will not have all these rights. I will not have all these obligations.
Okay.
But an improper donor will have all these rights and all these what? Obligations. Who is a proper donor? A proper donor is the one who goes through the donation, the sperm donation process as prescribed by the Human Fertilization and Embryology Authority. So the paperwork is done, everybody is aware, and they know that once the sperm is donated, your job is done.
It's done. And you take your reward. If
there is, that's it. You don't come back. So you don't look back after you have donated. So let's put it that way. You don't look back. Or if you look back, you go blind, literally. But nobody will listen to you. But your rights are taken away. The person who didn't go through the process will ordinarily be an improper donor, right? But those people, they can look back and be accepted.
Is that what it's saying, as we find on the screen? If you use an unlicensed clinic to donate sperm, you will be the legal father of any child born from your donation under UK law.
Very good. And you see that is, this one is information, right? The sign there. If you are an improper donor, I want us to contextualize it in our language, the way we understand. On license, and all that. If you don't go through the right process, you go to a corner shop to give the sperm, or you put the sperm in a condom, tie it, and give it out, or you leave it somewhere and somebody goes to pick it up with a swab. All these are not proper because they don't go through the right
procedure.
The right procedure is where the government has prescribed using those clinics. So we have the approved fertilization centers. You have to go through one of them. If you don't go through one of them and you do it anyway, whichever means, you've done it, I didn't follow the rule. And if you didn't follow the rule, your obligation as a parent will be there for you. And your right as a parent will remain for you. The person that will be at disadvantage will be the beneficiary of the donee.
Okay.
Now let's put it into context. You are a beneficiary. I am the donor. This is Amma. And that is the child. We call the child what?
Joe Blocks.
Joe Blocks. Okay. But okay. Amma gave birth to Joe Blocks.
Yes.
Okay. Yeah. Okay. All right. So that's fine. So now I donate to Amma. Amma is your wife or your girlfriend, your partner. So ordinarily, you should have done what I'm doing. But for other reasons,
you are not able to do that. Yeah, and you need that.
Exactly. So I'm helping. And this is our arrangement. Child is not in here, so three of us will sit down in the room and say, "Are you, Charles? You are my friend." Yeah. Are you self? You can help me. Really? How? Yeah. Just give it and let her use it. Just help me. Help a friend.
Me. Yeah.
Oh, really? Just like that? Oh. I'll give you the spare one.
Okay. Yeah, friend.
So, a friend. So I discharge and give it out. Amma uses it. It works. Joe Blocks is born. Who is the father? Then we go into the
realm of the law. Yes.
What does the rule say? First, how the arrangement should be set out. The reason that the arrangement should be within licensed process through licensed clinics.
Right.
And one, did we contact any licensed clinic? We sat in our room.
We sat
at the park. We met somewhere, even on the phone, and we did it. So there was no proper process.
Yeah.
And so we did it without the knowledge of the authority. Yeah. Can the authority protect you?
No, you
the recipient. No. You took the risk. You bear the consequence. And what's the consequence?
It
If I change my mind, Joe Blocks is my child.
My child, yeah.
Because what does the rule say? It says that if you do it through unlicensed clinics or unlicensed process, or you do it yourself, like DIY, DIY. So if you go through the process through DIY means, the donor is the father.
Yeah.
Good. Now, so we've understood that bit. The next thing we are going to look at is, now that we know that there are two fathers here, there's going to be contention.
Yeah.
If I tell you that I'm taking over Joe Blocks, you say, hang on, but that's not what we said. And that's
you decided to help me. So why are you looking back?
This wasn't part of the game. Why are you looking back? Yeah, I'm looking back because I've changed my mind. Is the sperm your sperm?
No.
So, who sperms fathers? So I am the father. And so, oh my God, I can't take this one.
So I'll go to court.
Go to court. I will go to court. And what will the court say? The court will look at two things: whether it makes moral sense to side with me or side with him, or we should stick to the law. Under our circumstance, we don't have any public interest consideration. Just one child involved. Just us. So it's not a case of I've been going around doing this. And so the judge or the court will say, no, we have to prevent him from becoming a father to the child for the sake of. This is simple, straightforward.
Yeah.
And this is where the judge would then stick with the law. And the judge will say, okay, let's look at what the law says. First, the first part of the law is for the court to refer to what the authority has to say. So the court will make a notice to the authority to please tell the court what the process say for sperm donation and right of the donor. What would the authority say? The authority is likely to come back to say that within the rules, the person who didn't tell us and does so himself
is still the legal father.
So the judge said, oh, if that is the case, who is the father? I am. Point one. Then we go to point two. Section 55A of the Family Law Act of 1986. Producer, are you there? Please help us with this law.
So let's get to that reference material. The Section 55 of the Family Law Act of 1986.
55A, yeah. So what does this say?
55A. And it says that subject to the following provisions of this section, any person may apply to the High Court or the Family Court for a declaration as to whether or not a person named in the application is or was the parent of another person so named. Point 2 says a court shall have jurisdiction to entertain an application under subsection 1 above if and only if either of the persons named in it for the purposes of that subsection A is domiciled in England and Wales on the date of the application, or B has been habitually resident in England and Wales throughout the period of 1 year ending with that date, or died before that date, and it continues live from there.
Yeah, so for the purposes of this conversation, we are not even interested in whether the court has power to make a declaration or not. We assume that the court has. And so 55A II will not be bothered. We'll be only interested in the I. Now, we are told that any person can can ask the court to make a declaration as to who the father of Joe Blocks is.
Of Joe Blocks, yeah.
So you have me, so you have C and you have K. Who is the father of Joe Blocks? So then I want to be known as the father, right? Because I have misunderstanding with you. I've changed my mind. I can't take back my sperm, but I can take back the product of my sperm, which is the child. So I want my child. I am the father. So I have made an application to the High Court seeking a declaration that I am the father of Joe Blocks. The court will have to have a recourse to the law as to what the process say, because this is about sperm donation. So the court then make a referral to the authority. Authority has confirmed that if they didn't follow the process, then the donor is the father. So according to the prescribed formality, I tend to be the father because we didn't go through the process. We just sat in a corner and did this do it yourself process.
Okay.
So the government doesn't know, and so the government cannot protect K. The government will side with C. Right, so that's point one. And therefore, the judge will make a declaration that from the processes and in the interest of the upholding, remember, regulation of fertilization and so on and so forth, we'll have to stick to the rule. And so C is the father of Joe Bloggs.
Okay.
Now the judge has confirmed that I am the father.
Right.
Remember, within the rules, we are told that if you are not if you follow the process, you cannot name the child. You cannot have your name on the birth certificate. So all this while, your name is on the birth certificate. All this while, you named Joe Bloggs. Actually, it is you and and Amma who gave the name Joe Bloggs to the child.
To the child.
Because I went away and I only came back when the child was 6 months old, or even 1 year old, or even 17-year-old. I want to claim my child. It doesn't matter how long. Child is still a child. So I come into the scene to understand or to know that somebody has named the child for me. Somebody has registered the child for me. So because I didn't contribute to this process, I can then go to court and seek what we call specific issue order, where I will say that I want the name of the child changed under Section 8 of the Children Act of 1989. You can have the name changed. These are specific issues. So we have two issues here, the name of the child and the birth registration of the child. And now that the judge under Section 55A 1II of the Family Law Act has agreed with me to be the father of Joe Bloggs, I'll make another application to the family court seeking an order that I can name the child. And then I will name the child. Also seeking an order that my name should appear on the child's birth certificate as the father. Once I've gone through the first hurdle and won, I will likely succeed at the next level. But there's no public interest concerned here, issues here. So just pure law. So on both fronts, I have succeeded. And once I have gotten the order under Section 8 for me to be able to name the child and register the child, I'll go to the registrar to seek an amendment and reissue of the birth certificate.
The records of a child, yeah.
And once that is done, the next thing I can do, because it's still contentious, is to prove that I am the child indeed, and the father indeed, DNA. So I can also volunteer DNA to confirm that I am the father. I've got the DNA confirming that I am the father. I've got the birth certificate of the child issued in accordance with the rules that I am the named father, and I have registered my child. With this, it takes us into our conversation for today. Can I now rely on Joe Bloggs? Can I rely on my child, Joe Bloggs, to make an application to remain in the UK because I am an overstayer and I want to regularize my stay?
So in effect, if the arrangement happened in the view of the authority and therefore went through the legal processes, and then what the gov.gov says that you cannot be A, B, C, D, and all that. When you follow that process, then you have no business going back, and no court will listen to you.
No court will listen to you.
Okay. But if you didn't and you did a DIY, then it brings us to this realm of our conversation.
Exactly.
Okay.
So, producer, let's go back to the HFCA of government website, the one with warning. Okay, so Ragoku, the first 1, 2, 3, 4, 5 are the rights and responsibilities for those who do the right thing.
The right thing, yeah.
And the warning there is for those who don't do the right thing, but in a way they have a right.
Yeah.
So the warning is for people who accept sperm donation improperly or without
going through the right process.
Yeah, without going through the right process.
Mm-hmm.
And the first set for those who go through the right process. So it says that if you don't go through the right process, what happens to you?
So you get the legal father, or you'll be the legal father, so to speak, of any child born from your donation under UK law.
Under our discussion, we have C and we have K.
Mm-hmm.
I'm the donor, and you are the recipient
or the beneficiary, of
the donation.
Mm-hmm.
We didn't go through the right process. So this warning, is it for me or for you?
The warning is, to be fair, it's for you, because
but that one is giving me right.
It's giving you right. But, well, obviously. So it's warning me as the beneficiary of the donation, that if you ask for such a favor, go through the right procedure.
Otherwise,
the person who is doing you the favor would have the legal right.
Exactly.
And the law behind the person.
Exactly. Okay. So they are warning K that K is fine. Your friend C can help you, but take him to the clinic so that everything will be witnessed properly. Okay. If you don't do it and you go ahead and do it yourself, the process will succeed, but it may come back to bite you. So be warned.
Okay.
They say, oh my God, the clinic is going to take forever. It's so expensive. Oh man, he's my friend. We've grown up. Oh, you know what? Let's go ahead.
Even if at the time of the discussion, you both will put pen to paper to say that these are the things that we expect to happen after it has been successful. Then we quote the bits on the screen. We will not be the legal father. You will not have any legal obligation, have any rights, and we put our name to pen.
Read. What does it say?
If you donate sperm through a human fertilization and embryology authority, you will not.
You will not. So in other words, if you do it through you'll be the beneficiary will be the father, right?
Mm-hmm.
Good. So they are telling K, if you do it through us, you are the father. If you don't do it through us, your friend will be the father. And K is saying that, oh, but you are following the rules. It's pen. You printed, which will print the same thing. Will copy from you. You copy.
Yes.
Are they aware?
No.
And they are saying if we are not aware, we can't protect you.
Right.
So no sentiments, no emotions. A and B. If A is B, then B is C. Commutative and associative.
But lawyer, before we take a quick break and come back to the nationality aspect of this whole discussion, let me ask. I sit down, K and C sit down, and Joe Blocks is born.
Yeah.
Whether we like it or not, we are aware that Joe Blocks has your DNA.
Yes.
But the law says I can't claim any rights. I get to a point where emotionally I am attached to Joe Blocks.
Who? K or C?
K.
K, of course.
Oh no, C is a donor.
Yeah.
Okay. C thinks that I'm attached to Joe Blocks.
If you pause
he so looks like me.
But if you pause there, how did C become attached? Because C, after donation, never got to know what happened next. You're supposed to live and live forever if you go through the clinic process.
Okay.
So even if the person looks like you haven't met the person before. So how will I say that?
That is thicker than water.
Then a lot of people are our brothers and sisters. But we ignore.
Yeah.
Because it's not true that we relate.
Okay.
Sometimes you see something, wow, this person, hey, the way you speak, the way you do, where do you come from? I come from China. Oh, then that one day, I don't think you are my brother. So imagine Joe Blocks is taken to America, grows up in America, and you meet this American child in China, me meeting him in China on holiday. So, hey, you look like me. Does that alone give me power to claim? Because I didn't know all that. And so the presumption here is this, that if you know that you go through the process, you have to forget forever, you wouldn't even have the appetite to come back.
Okay.
But if you know that you didn't go through the process, and you know you can change your mind, that's why people would be then feeding into the advice and suggestions of other people.
Okay.
He said, that child. Because I'll also be telling my friend that, oh, I'm a champion. I helped him. I did this. I did that, right? Then that child looks like you, you know. That child now is a footballer. He's playing already. Oh, really? Okay. You see. So you want to claim
your child back.
But you knew that if you had done the right thing, or if they had done the right thing, you wouldn't even have
the right.
To write to the child. But so the advice is simple. Yet, from the outset, it may appear easy, straightforward, and zero cost. But the consequence is dire. Because human beings remain human beings. We change our mind when it is necessary. And so nobody knew that C was going to change his mind. Because C presented everything to be wholesome. And on that basis, K bought into it. Only for K to change his mind, knowing that C to change it, knowing that K is going to benefit from this child. Maybe C didn't think that Joe Block will even be born. But now that Joe Block is born, maybe C doesn't even have a child of his own. Maybe C now is looking for a boy, never had it, and now I've given boy to somebody. Looking for a girl, never had it, I've given girl to somebody.
Why don't I go for my...
Looking for a twin, I never had it, I've given twin to somebody. Looking for a dog, I never had it, oh my God, I will claim it.
Well, can you get the law to be on your side when it comes to nationality matters? How does it present to you? The ruling, as we presented in our nuggets, talked about the case that was decided in April 2026 is about Ari and Ori N, and the court refused to recognize an unregulated sperm donor as the legal father of a child, even though DNA confirmed he was the biological parent. The case involved a private sperm donation arrangement outside a licensed fertility clinic. The court held that legal parenthood is not determined by genetics alone, and that recognizing the donor as a legal parent would undermine UK fertility laws designed to regulate sperm donation and protect children and family. This decision is an important reminder that private fertility and donor arrangement can have serious legal consequences. BWF Solicitors has brought this very complex and difficult conversation, and we're having it, and we're doing that live on BWTV, and the program is the community and the law. BWF Solicitors, located on the 4th floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters in North London. Call them on 0208 493 7340, 0208 493 7340, or in emergency situations call 077 127 61884. BWF Solicitors are trusted partners when it comes to the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back and thank you for sticking around. And I know you all are watching. Collins Kujo, thank you. Frank Bunsu, thank you for watching. Bel Gassem Schweib, I know you're watching. Mark Konai, Abigail Nyantachua, Elvis Nchi, Nana Jima, Nana Kofi, Barima Lacey, and Betty Kaki Okansi, Kwakopuni Asari, Mumin Abubakari watching live as well, and a host of you, Tricia. Thank you very much, Tricia Leo Doppel. You're also watching, and we believe that you are enjoying the discussion. If you have any question, you can put that in the comment section down below, on Facebook at BWF Solicitors and on YouTube at BWF Solicitors. Also, both Facebook and YouTube at BWTV. We're looking at sperm donation, the right process to go through. But if it does happen that you don't go through the right process, and as we have established earlier on, that the law says that if it doesn't go through the correct process, the donor is legally the father of the child. Now, Lawyer Charles Asma, a resource person and a special guest from BWS Solicitor, has outlined in a very practical way. We have C as the donor, K as the beneficiary of the donation, and A as the mother who received the sperm, carried the baby, and gave birth to Joe Bloggs. Now, Joe Bloggs has become the center of importance, center of attraction, and the benefit of Joe Bloggs being a qualifying child can see who is in need of a proper immigration status in the UK, rely on Joe Bloggs, who is a product of C's sperm donation done through the outside of law process, rely on him to make any immigration application. Lawyer, that's my big question.
Thank you very much. Yes, so we'll look at the status of Joe Bloggs in the first instance.
Mm-hmm.
And we'll do this with respect to K, the beneficiary father,
Mm-hmm.
and A, the mother who carried Joe Bloggs. Once we've defined the status,
Mm-hmm.
we'll check who gave status to Joe Bloggs. And that will determine whether Joe Bloggs can even give me any benefit at all as far as immigration conversation is concerned. So we'll first look at what the law says, and we will go to the Nationality, Immigration, Asylum Act of 2002. So producer, if you're available, please take us to section 117B1. 117D1 of Nationality, Immigration, Asylum Act of 2002.
Okay, so we have a resource on the screen talking about this is B.
D.
117D.
We'll come to B later, but go to D. D. And it's still under 117, but the D part, yes, D.
Yes, interpretation of this part.
Yeah.
And it says that in this part, Article 8 means Article 8 of the European Convention on Human Rights. Qualifying child means a person who is under the age of 18 and who is a British citizen or has lived in the UK for a continuous period of 7 years or more.
Full stop, right?
Yeah.
So we'll leave it on the screen, and producer, if you can put me on the side or on top, above, or anywhere. It's all over.
Yeah, it's all over.
All right. So now, Joe Blocks.
Mm-hmm.
So we are going to situate Joe Blocks within the interpretation of the law.
Okay.
So under section 117D1, and if you go down, it will be B, right?
Mm-hmm.
Yeah. So So 1171. So 117D1, it says that a qualifying child A is a British citizen.
Mm-hmm.
B, a child lived in the UK for 7 years. Joe Blocks was born just about let's say 6 months ago.
Okay.
So 7 years will not be at play. Mm-hmm. So B is out.
Okay.
But the 117D definition of a qualifying child has been extended beyond the 2 points we have. Mm-hmm. So I'm going to list the 3 more points that the law has recognized.
Okay.
So 1, if Joe Blocks is under 18 and Joe Blocks is British, then Joe Blocks is a qualifying child. Or Joe Blocks has lived in the UK for 7 years, Joe Blocks is a qualifying child. Joe Blocks has indefinite leave to remain, Joe Blocks is a qualifying child. Joe Blocks is an EU national with 5 years pre-settled, he is a qualifying child. Or he's an EU national with indefinite leave to remain, settled status, is a qualifying child.
Okay.
Now, whether Joe Blocks, who was born 6 months ago, is a qualifying child or not, depends on either K or A. Mm-hmm. The mother and the beneficiary father. Mm-hmm. Now, we realize that when Joe Blocks was born, A doesn't have. A just has 2.5 or even skilled worker visa. Mm-hmm. But K had indefinite leave to remain. Mm-hmm. And because of that, the child, Joe Blocks, became a qualifying child. Became a British citizen.
Because of the status of K.
Because of K's indefinite, mm-hmm. Joe Blocks has become under section 1, subsection 1 of the Nationality Act of 1981. So we say, Joe Blocks, you are a British citizen because when you were born, your father, K, had already been granted indefinite leave to remain. Your mother, A, only has skilled worker visa. So she couldn't have given you that power. Mm-hmm. But your father, your presumed father at the time, gave you the power to become a British citizen by operation of law. So Joe Blocks is a qualifying child.
Okay.
Now, me, C, coming in to say I'm the father. Judge has agreed that I am the father. So your right as a father has been taken away from you, right? So K is no longer the father. Mm-hmm. Now, I don't have anything. I'm an overstayer. So I couldn't give anything to Joe Blocks. Yeah. And you two couldn't have given because you are not the father.
You are not the father. You were not in the picture at the time.
No, you were there and you thought that you were the father. Mm-hmm. So you did everything. Now the judge says you are not the father. Mm-hmm. I am the father. Mm-hmm. So the power you gave to Joe Blocks, we have to take it away. Okay. So we have now taken away Joe Blocks' what? Citizenship. Now Joe Blocks is bare. We go to the mother. The mother is skilled worker. Joe Blocks cannot have it because the time the mother had her skilled worker visa, she
wasn't settled.
No, it was after 11th of March 2024, which says that because she had her skilled worker care visa after that date, all the dependents cannot also have it. So
Okay.
the child can have it from the mother. The child has been asked to give up the one he had from the presumed father. Me, the biological father too, I don't have anything to give the child. So the child becomes an overstayer, literally.
So then C cannot depend on the
So
child.
the question is, what's the point of what C is seeking to do?
Yeah.
So C will do it only if he knows that there's something in it for him. And then we have to trace it to the mother, A. Because A is enshrined, it's absolute. So if it is the other way around, then A, being the settled status person,
would
give it to the child.
Confer that to
exactly.
Joe Blocks.
And Joe Blocks has
and then C can depend on
good.
Joe
In that
Blocks.
case, Joe Blocks is a qualifying child under section 117D 1B of the rules. Now, we've determined that this child has gold to offer. So I'm going to tap into the gold. Okay. What does the law say? The law has given me the parental responsibility, right? Because I am the father now. The next thing is to see whether I can rely on Joe Blocks for application. And that will take us to section 117B 6 of the Nationality, Immigration, Asylum Act of 2002. So producer, take us to section 117B.
117B, scroll up to the top, 117B, public interest.
B6. Go to
B6. Okay.
Yeah.
In the case of a person who is not liable to deportation, the public interest does not require the person's removal where the person has a genuine and subsisting parental relationship with a qualifying child.
Full stop. So that is C. We are talking about C, right? C wants to rely on a qualifying child, Joe Blocks. Right. Have we established that Joe Blocks is a qualifying child? Yes. Yes. Because we have been able to trace it to the mother. Instead of the father, we've gone back to the mother and we realized that the mother can also give him, so he's still a British citizen. Okay. So I have then also checked I've checked the DNA, I am the father. We've checked the birth certificate, I am the father. The new birth certificate that has been issued after the court declaration, I am the father. So, but 117B says, if I want to rely on my child, Joe Blocks, then I have to show that 1, I'm not liable to deportation, and 2, I have a genuine and subsisting parental relationship with Joe Blocks. And that is another test for me. Okay. I have to show that I look after the child.
That would be a difficult one to prove.
That is the next hurdle. Because I'm at loggerhead with K and A. How will I presumably be able to look after
Joe Blocks?
But then, I go back to the authority and say that the person who doesn't go through the process has obligation to look after the child. So I'll go to the court again and tell the court that, court, remember the last time I came, you agreed I am the father. The judge will say, oh yeah, we remember. Yeah. Then I'll say, this time, I want you to command them to give me right to look after my child. We call it Section 8, Child Arrangement Order.
Oh, okay.
So once I get child arrangement order from the court under Section 8 of the Children Act of 1989, court has told me what I can do for the child. Go and visit the child. If they don't want you to come home, go and meet them at McDonald's, and they have to bring the child for me to say, hello, Joe.
It's an order.
It's an order. You have to comply. And that has given me subsisting parental relationship. Okay. But it's an ongoing order from court. All I have to do is to keep to the order. They say every Sunday afternoon, meet them at McDonald's and spend half an hour with the child. We call it contact access. So there are people there, supervise contact. There are people there to see me with a child, be it the parent, social service, whoever. Nobody cares. All I want is I have a chance to see the child. I go to meet them at McDonald's. I play with my child and got photos to show what I'm doing. Even if I don't have photos, court knows that I'm complying with the order. So then when I'm making my application, I go to court and tell the court that, remember, the law says that if I want to rely on this order, you must give me permission so that I can show it to a third party, the Home Office. The court will give me permission to use this paper in my application. And once the court does so, I will add it to my passport or my document, and I'll send it to the Home Office to say that, 1, I am the father, my DNA, my birth certificate. 2, Joe Blocks is my child. Everything is here. 3, Joe Blocks is a qualifying child. Joe Blocks is British through the mother. 4, I have contact order
from the
court to see the child, and I do so, and I haven't broken the order. So I have met section 117D1 and 117B6. And so my application must be considered in the interest of the child. Then 117B6B will come in. Please, what does B say?
It would not be reasonable to expect the child to leave the UK.
Yeah. It will not be reasonable for a child who is bonding with the father C to leave the UK with the father if you ask the father to leave. Because if you send me to my country, how would the child have the contact with me?
Yeah.
And how will I keep to the court order? So you can't. Then I also rely on section 55 of the Border Citizenship and Immigration Act of 2009, what we call the Borders Act, and tell the court that it is all that I want the Home Office to do is to give me chance to remain in the UK and look after my child. But the court has ordered me to be a parent to this child. So if not for me,
it's for the child.
So in the best interest
of Joe Blocks. Well, listen, you would have to have your wits around you, so to speak, to be able to look at various aspects of the law, bring them together in your interest. And I believe that you can trust BWF solicitors to help us with that. We have been looking at whether a sperm donor can claim paternity right and also rely on the child to remain in the UK. Now, the scenario has been established. You will remember Lawyer Asma mentioned that there must be a qualifying child. How do we determine the qualification of this child as a qualifying child in this situation where anybody can take advantage or even use that situation as an opportunity to regularize their stay here in the UK? Then the second step is where you have to establish responsibility for the child. You can go to the court for a court order and all the rest of it. Is there any other hurdle that a person like this should overcome, lawyer?
So we are told that you have to show that your relationship with the child is ongoing, subsisting under the law.
Okay.
You have contact with the child, so you see the child, you visit the child. What else do you do?
Right.
What do responsible fathers do? So on the birthday of the child, even if they won't take it, you send it. You give money. If they won't take it, let the witnesses know that you are doing your job. Can even call child maintenance to say that I'm offering financial assistance to my child. The mother is rejecting it. I want it to be formalized through the child maintenance service process so that it goes into her bank account from my bank account. And you will supervise that. Yeah, that's also evidence that you are looking after your child. Once you have a couple of those things, yes, it will be in the best interest of the child for you to be granted 2.5 under paragraph EX1 of the immigration rules, because you don't have a visa. Because I don't have a visa myself, I will not be able to apply under the standard rules and the 5-year route. But I can apply under 10-year route on the basis that there is exceptional circumstance under EX1, where if you don't give it to me, it will affect the child. Because I'm not living with them, I cannot rely on Gen 3.2. But I'm living elsewhere, and so EX1 will come in, Section 55 will come in, 117D will come in, 117B will come in. So this alone, how many laws have we relied on?
Oh my God, a lot. A lot. But you know what? If it is that you would want to get support for some of these things, proper legal advice, and also people who know what it is that they are doing, I would recommend that you contact BWF Solicitors, 4th floor of the House, 214 to 218, Tottenham High Road, Seven Sisters, North London. Call them on 0208 493 7340. Now, I'm going to give you the opportunity to ask your questions. The lines are active: 0208 493 7345, 0208 493 7345, or you can leave them in the comment section down below, either on Facebook or YouTube at BWF Solicitors. I'm going to ask you this question in a scenario. I won't take the answers. We will allow lawyer Asma to answer some of your questions, and then I come to ask you which of the three options would be the right answer. Bola and BC are married but unable to have children due to Bola's low sperm count. They agreed for Femi, a family friend, to donate a sperm for them to enable them to have a baby. Femi gladly accepted to help a friend in need. The arrangement did not follow laid down process for sperm donation in the UK. A year later, Emeka was born. Bola and BC registered their child's birth certificate, and the certificate was duly issued, showing them as parents of Emeka. 8 months after Emeka's birth, Femi made an application to the family court seeking a declaration that he is the father of Emeka. Bola is disturbed. Let's advise him on the likely outcome of Femi's application. We've got three options quickly. The court will grant the application because Femi's sperm formed Emeka. The court will grant the application because the sperm donation arrangement did not follow the prescribed process to guarantee Bola as the father. And the third option is the court will decide based on who BC believes to be the father of her child. Think through this. I'll pick up the answers. But now we're going to pick up your questions and comments. So we direct them to Lawyer Charles Oswald to help us answer that. 0208 493 7345. The lines are active. And also you can put them in the comment section down below. Or send a text 07399208 It's still the community. And the law is brought to you by BWF Solicitors. Now let's see what you have brought in last month here. Mayao, if you have a visitor's visa in your passport, do you still need an e-visa when you want to visit the UK?
So you have visitor's visa in your passport. Do you need e-visa when you want to? No. Visitor's visa, you are not living in the UK, so you don't need e-visa.
Okay. Well, quickly, let's go to the next one. And we have Papa J. Can someone stand on his stepdaughter to apply for further leave to remain? And if so, how does one go about it?
Yes, so the same process as Joe Block's case we had today. Okay. Just that this time you are a step. You have to triangulate the evidence. To triangulate means you need more than just one. If you are the biological, all you need is your birth certificate, the birth certificate of the child. But because in this case, you are not the biological, you have to show that you are married to the mother of the child, which is marriage certificate, or you have lived with the mother of the child for 2 years for you to become a de facto stepfather. And again, if not, then both of you must go to court and ask the court to grant you what we call step-parent responsibility order for you to assert your rights as a parent in helping that child. Then from there, you have to show that your relationship is ongoing with the child and you are assisting the child with all the support necessary, GP letters, school letters, depending on whether the child is of school-going age, and also the fact that you are living together as partners and with your child. Your application will come under Gen 3.2 and 3.1 of the immigration rules, Appendix FM, and all the things we said today will apply to your case. Section 117D, Section 117B of the Nationality, Immigration, Asylum Act of 2002. All these things will come into play. And we've mentioned the theory and the law. What you need is evidence to support that you have met the requirements.
Thank you very much, Papa J, for your question. And thank you, lawyer, for helping us with that. The next one is coming from Me in Dabozo. My student visa has been cancelled. Cancelled, and I joined the army. I don't know what it is. That please, my visa has cancelled, and I joined the army. I don't know whether you want to say if you can join the army. Yeah. Okay. Let's situate it where he wants to join the army after being thrown out of school. If I should put it that way.
Well, if your student visa has been cancelled and the army needs you badly, they will accept that you are an overstayer and still recruit you. Once they recruit you, you don't need visa to serve the crown. So you'll be somebody who is exempted from immigration control. And the army will do the paperwork, let the Home Office know all that, and you will live your life and serve the crown.
Well, you want to serve the crown, your circumstance can help as well, and they would consider this on a case-by-case basis. Can I switch from student dependent to marriage for the next 15 days? Because the girl failed some course and we have 15 days left. The Nakwesi is asking.
Okay, let's break it down.
Mm-hmm.
Can I switch student dependent
Mm-hmm.
to marriage
the next 15 days?
Now, let's put this aside
Mm-hmm.
and look at the common sense aspect and the logic.
Mm-hmm.
This person has told us why they want to marry, right?
Mm-hmm.
Why do they want to marry?
Because the visa is cancelled.
That is marriage of convenience.
Yeah. So you can't do it.
Because you can't marry within 15 days, apply within 15 days, and for anybody to believe that this is proper reason for marriage. You marry for love, not for purpose. And so it wouldn't even make sense for me to even comment. But it doesn't follow the process of marriage. So no, this one, it doesn't make sense. It has the semblance of marriage of convenience, and the application will fail for that reason.
Now, I see, that's the advice from the lawyer. Take it, because as he said, the common sense approach to the whole thing. Yes, keep it coming through. Enokakoto Marfo, do you need life in the UK for indefinite leave to remain application under EU rules?
Life in the UK for, yes. Oh, under EU rules.
Yeah.
Now, under EU, you see, that's the beauty of EU. It's so sad that Britain left the EU, but it's what it is. Everything EU is holy.
I love that.
Everything EU is holy. You're applying to bring your child, so holy that you don't need to do anything. All you have to do is, this is my child. If you want to bring your child who is even 100 years, all you have to do is that, this is my child. I still look after him or her. You want to marry, all you have to do is, you don't have to show 29,000. You want to apply for indefinite leave to remain, you don't have to show life in the UK or English. That is the beauty of the withdrawal agreement of 2020. And our brother Enoch, you are fortunate. The law is with you. Go and apply. No need to hustle.
Well, Akotomafu, thank you very much for bringing the law's on your side, as lawyer has said. We will be taking a couple more and then round it up today. You have 2.5 visa based on my child. Can I travel from UK to any European country for 2 weeks? You have 2.5 visa, so you're not settled in the UK, I guess. Can I travel to any European country?
Oh, from UK to any European country for. All right. So this person has leave to remain in the UK. They are living their lives. They have enough time. The visa hasn't expired. It's not about to expire. This person wants to go on holiday. It's a matter of fact, if you want to go on holiday, you can even go to the moon. All you have to do is get a moon visa. So if you want to go to Europe, get a visa to Europe. You go and come. Full stop.
Sometimes people think, I think I understand the premise of her question, so to speak. That, well, I'm in the UK. UK, unfortunately, is not part of the EU anymore. So can't I go? But Faustina, as lawyer has said, you want to go to the moon. Let people living on the moon allow you to come in.
That's all.
That's all it
It doesn't
is.
really matter whether it is EU or it is America, China. You can go anywhere. As long as you apply for your visa and you get a visa, you go
And come back.
and come back.
Mm.
And once you have visa to come back, that's it. The officer will ask you, where did you go? I went to the moon. They needed me. Oh, welcome back. They'll ask you, how was the moon? Oh, moon is fantastic. It's a matter of fact, better than the F.
You've gone to the moon. You're back. Anyway, let's pick up the next one here quickly. We have one from Solomon Nana Kwesifosu. Is it mandatory to include photographs of the marriage ceremony, copies of witnesses and representatives' IDs, or is the attestation of the marriage by the Ghana High Commission sufficient on its own?
Right. So there's something in general parlance, not even law or anything. They say that if, see this paper I'm holding.
Mm-hmm.
Okay, this thing I'm holding, not even paper. What am I holding? Somebody will say paper.
Mm-hmm.
Somebody will say card. Somebody will say plastic. It doesn't matter how you say it. Depends on the glasses you are wearing.
Mm-hmm.
So the general balance is that if it smells like paper, if it looks like paper, and it feels like paper, then it is
a paper.
The same way, if it is wood, and all these three criteria are met, then it is wood. Let's apply it.
Mm-hmm.
He's married.
Right.
He's asking, should I add pictures? When people marry, do they usually take pictures? And what for?
Mm-hmm. Evidence.
Not evidence.
Memories.
Memory. Not evidence. Because you don't need to prove to anybody.
Mm-hmm.
That's why people do secret marriage, secret wedding.
Mm.
So you don't have to prove yourself to anybody. But memories. So for the sake of memory, you have pictures.
Mm-hmm.
There's no law asking you to take pictures, but memory. So you have it. Now, if you are supposed to prove to somebody that you and Mary married, and Mary is saying that, no, I didn't marry him. You have memory to support you. And that becomes evidence of your marriage.
Okay.
At the time, it wasn't evidence, but now it's helping you. That's the context.
Mm-hmm.
We come to Ghana High Commission. Well, I have to send it to them for them to endorse. We have different marriage type in Ghana. Because this is Ghana, right? It's Ghana, yeah. So we have the marriage under the ordinance provisions and marriage under the customary marriage provisions. So the customary provisions, you go through the process, then either both of you were there or not. You have to take it to the government agencies in Ghana for them to do whatever. Mm-hmm. When you bring it to the UK, we have Ghana government in the UK represented by the Ghana ambassador. So you go to the High Commissioner to say that Mama Zita, is Zita, right? Mm-hmm. Mama Zita, I married in Ghana. Everything has been done. Can you also say that it is true? Mama Zita will endorse it.
Is it a necessary of the requirement?
What are you trying to do?
Just to reinforce it.
Reinforce. You're trying to show off, really.
Okay.
If showing off is good, why don't you show off? By all means. So to reinforce the fact that it is indeed valid in that country. Mm-hmm. So even if you don't agree with what was done there, what about an independent government rep? So that is why we say go to them, let them endorse as well. But usually, you want to prove that the marriage is valid. Mm-hmm. There's case law, there is statute, and there are other rules to support that claim. That if the marriage is valid in Ghana, then it must be recognized in the UK. Because these are sovereign states. And what you need to know is that you follow the process in Ghana to make the marriage valid. And what does the process say? Under Section 3 of the Marriage Act, the 1984, the 1884 to 1985 Act, it says that if you marry, the marriage will take place at home in Ghana, what we call customary marriage. Every marriage is actually customary, because the family members come together and do their indoor conversation, agree and accept things. The marriage is sealed. If you wish, the law says that you can go to the government and register the marriage. Why do we register the marriage? At home, during the marriage ceremony, it's just family members and friends, right? Apart from pictures, what else do you have to prove that you married?
There's no
Nothing.
certificate behind it.
So if you want anybody, apart from those people who were there, to know that you are married, you tell the government to confirm it. That's registration. So once you've registered, you can show it to anybody. So imagine you want to tell the UK government that you are married, and all you have is your family members in the photo. They wouldn't accept it because there's no certification. And that's why you go to the registrar to have it registered under Section 3, Section 5 of the Marriage Act. And it says can be done at any time. So you go and get it done. So one, you have the certificate issued. You have the district assembly where the marriage took place also giving you certificates. So 2 certificates. And actually the district assembly will give you a letter of verification or authentication that this is registered. Then you go to court so that the family members who represented both of you at the marriage ceremony will make a declaration. We call it statutory declaration. Then from there, you take it to the Ministry of Foreign Affairs, where the minister will confirm that the signatures we see on the certificate are valid and therefore the thing is valid. You go to court for the court registrar to also add a letter to confirm things. So you have how many? 1, 2, 3, 4 pieces of evidence. When you bring it to the UK, you take it to the High Commissioner to also give you 1 piece of paper. That is done. But think about this way. You appointed your family members to represent you, right? What shows that you appointed them?
You need some attestation.
We call it power of authority or power of attorney. So you give them that power of attorney to show that I gave power to Kojo Menu, who is my uncle, to represent me. She gave permission to somebody who is a family member to represent her. And these are pieces of authorities we gave. We call it power of attorney. That can be done. So once you bring the certificates to the UK, you take it to any law firm. You can bring it to us. We do it. We'll prepare power of attorney sealed. Sealed. Then, of course, that must also be before you even marry. Because you have to give the power before you marry. So presumably, this would have been done before you married. Once you know the date of marriage and all that, when you are going to marry, all this, then you give the power. So the power will precede the marriage ceremony or the registration. Then we are adults. Because the rules say you must be adult, 18 and above, no pressure and all that. How do we know that nobody put us under pressure to marry? So we must freely express that we consented. So you do what we call letter of consent. That I'm free, I so and so accept, agree to marry Mary so and so, blah 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 blah, and not under any pressure. And Mary will also do the same thing. We both sign, and we have it added to the document and present it to the caseworker. And we'll tell the caseworker that your law says if the marriage is valid in Ghana, it is recognized in the UK. We've gone through all the validity process in Ghana, and this is everything we need from Ghana. Marriage is valid in Ghana. So what do you say? Full stop.
Well, and on that note, I will ask Lawyer Asma. I'm going to go do my traditional thing, customarily, and ask you. We had a very difficult conversation earlier on, and today I'm going to be very strict on you. I'm going to ask you to do our summary in 2 minutes.
Thank you very much. So viewers and listeners, today we looked at the law with respect to family rights and immigration rights. We looked at people who donate sperm without going through the standard process, whether they have rights that as parents, fathers, to rely on the child born out of the sperm donation to make immigration application. We understood that the law is on their side. The Human Fertilization and Embryology Authority says that if you don't go through the right process, the father of the child will be the donor. Therefore, if the donor of the sperm is now the father of the child because they didn't follow the process, then this father of the child, who is an overstayer, can rely on the child. If the mother of the child, for example, is British and so the child is British, or the mother of the child has indefinite and so the child is British, to be able to rely on this child, you have to now show that you've asked the court to give you the authority to become the father. You ask the certificate, the birth registrar to reissue the birth certificate so that your name will appear as the father. You also carry out DNA to confirm that you are the father. With this, you make application to court to give you what we call right of access to the child. We call it child arrangement order. That is where the mother of the child and the other man, that is the boyfriend or the husband of this woman, are saying that they will not allow you to participate in the care of the child. You can ask the court to give you the power to be able to look after your child. That is called child arrangement order under Section 8 of the Children Act of 1989. Once you get that, you then have to show that you look after the child. In this case, if you are not having the opportunity to look after them and look after the child, you can ask the child maintenance service to take the money from you and give to the mother for the upkeep of the child. Once you have all these pieces of evidence, you ask the court to give you permission to rely on the child arrangement order that the court issued. You take it to the Home Office with your application, supported by other documents, and ask the Home Office to grant you 2.5 as a parent of a qualifying child, because the child is British and you have genuine and genuine and subsisting parental responsibility with the child. Because it will be in the best interest of the child for you to be granted 2.5 so that you can look after the child, the law says that you must be granted. Otherwise, it will not be fair to the child. And that will come under Article 8 and also Section 55 of the Borders Act and other areas of the immigration rules that we have quoted, including EX1, paragraph EX1 of Appendix FM, and also Section 117D, 1 of the Nationality, Immigration and Asylum Act of 2002, and Section 117B6B of the Nationality, Immigration and Asylum Act of 2002. Putting all this together, on a balance of probabilities, you are likely to succeed that you'll be granted 2.5 to be able to support in looking after the child. Even though you donated the sperm, what is in your favor is that the right donation process was not followed, and you win on technical grounds. Thank you.
And with that, I want to say thank you to Lawyer Charles Asma. But before you go away from me, he has more or less answered my quiz question. So I am going to ask you to give me the answer. I'll go back to him to ask for any response, but I'll ask you to look at this. I'm going to read that quickly, give you my social media handles, and drop your questions. Then we'll answer and draw the curtains down. A different arrangement for today. Bola BC are married but unable to have children due to Bola's low sperm count. They agreed for Femi, a family friend, to donate a sperm and all that. The arrangement did not follow laid out process for sperm donation in the UK. Emeka is born out of that. The registered child's birth certificate was given, duly issued with them as parents of a baby. 8 months after that, Femi made an application to the family court seeking a declaration that he is the father of a child. He's disturbed. That is the beneficiary father is disturbed, Bola. Would the court grant the application because Femi sperm formed Emeka? Would a court grant the application because the sperm donation arrangement did not follow the prescribed process to guarantee Bola as the father? And would the court decide based on who BC believes is to be the father of the child? I'll be right back. Well. Let's see what advice we can give, or what will the likely outcome will be. Kwabna Sari says that the court will decide based on who Bisa believes to be the father of a child. The next one is from Mavis Fusia. Mavis says the court will grant the application because Femi Sperm formed Emeka. Richmond said thinks it's number 3. The court will decide based on who Mrs. believes to be the father of a child. Kofi Arthur says the court will grant the application because the sperm donation arrangement did not follow the process prescribed. Kweku Bright Smening also thinks it's number 2, that the court will grant the application because it don't follow the process. Abna Dennis thinks it's number 3. Thank you, Abna. Next one is from Kwabna Pia. Kwabna Pia says number 1. Next is from Ajwa Sewa. Ajwa Sewa says it's number 1. Well, let's look at what Equiat Newton says. The court will grant the application because the sperm donation arrangement did not follow the prescribed process to guarantee Bola as the father. That's number 2. Cantona P. Alexander, he thinks it's number 3. The court will decide based on who BC believes to be the father of the child. His queen is saying number 2. Thank you, his queen. We go to the next one. Dennis Boateng, he thinks it's number 1. Thank you, Dennis. The next bit is from Margaret Boachi. Margaret Boachi says the court will grant, that's number 2, will grant the application because the sperm donation arrangements did not follow the prescribed process to guarantee Bola as the father. Higa Kakari says number 2 as well. Thank you, Higa. The next one is from Kenjo Ajay. Kenjo Ajay says it's number 3. BC would have to determine who the father is. Letitia Pepra says number 1. The court will grant the application because Femi Sperm is formed by Emeka, or Femi's sperm formed Emeka, so to speak. Well, let's go and get the correct answer. Lawyer really answered it. Okay, there's one more. Tilly, you're always late. Why? You have to wait till I answer the question before you come in. Okay, now you say it's number 2. The court will grant the application because the sperm donation arrangement did not follow the prescribed process to guarantee Bola as the father. Now listen, remember, let's go to the nugget where the ruling was outlined. Now, it says that the High Court refused, in that case, Re-N claiming that a family court in 2026, that's April 2026, when we saw the details, the High Court refused to recognize an unregulated sperm donor as the legal father of a child, even though DNA confirmed he was the biological parent. The case involved a private sperm donation arrangement outside a licensed fertility clinic. The court held that the legal parenthood is not determined by genetics alone, and that recognizing the donor as a legal parent would undermine UK fertility laws designed to regulate sperm donation and protect children and families. But you remember when lawyer was explaining that he took us to the ruling, the government website where the arrangements were outlined, and it said that if you went through the authority and you made them aware and you went through a recognized fertility clinic, then the person that made the donation will not have certain rights. But if they did not, it says You will not be the legal parent of any child born. You will not have any legal obligation to any child born. You will not have any rights over how the child will be brought up. You will not be asked to support the child financially, and you will not be named on the birth certificate. But then it provides further information and says if you use an unlicensed clinic to donate sperm, you will be the legal father of any child born from your donation under UK law. Now let's see what answer would be correct for our friend. The person who is claiming is Emeka. No, sorry. The person who is claiming is Femi. So let's see what will happen to Bola, who is disturbed because of Femi's application. Is the court going to grant that application to Femi or not? And the answer is number 2. Yes. So, I went around it. Today I'm trying to be a lawyer. That's very good. The court will determine that Femi is Emeka's father because the arrangement between the parties to receive sperm donation from Femi did not protect Bola from losing his rights as Emeka's father. In fact, the court will decide on paternity of a child born through sperm donation arrangement based on laid down process for sperm donation in the UK. Even though the court's decision will be based on public policy, in most straightforward cases such as this one that we're talking about, a father accepting a sperm donation through an unregulated process risks losing his paternity rights to the sperm donor. So the answer, as we said, is number 2. Those who did that, congratulations, well done. You've done so very well. And on that note, I would want to once again thank all of you out there for your time this afternoon. Those who have joined us quite recently, probably being the first time, or you've received the invite as a first time viewer. Thank you for joining us. Yeah, Tilly, you got it right. Thank you very much for your answer. And to those who did not get it right, I've explained as to why it is so. On behalf of the team and on your behalf, we want to say thank you to BWF Solicitors, our partners, and of course, our reliable lawyers for giving us the opportunity to come your way with another edition of the Community and the Law. Call them on 0208 493 7340. If you're in Ghana, they have an office, and you can call them on 055 589 5959. In emergency situations, 077 is a UK number, 077 127 61884. Or you visit the various social media platforms, BWF Solicitors. Website, www.bwfsolicitors.com. I worked with Shilankra and Pat Mododu. My studio producer was Professor Ade. My name is Oreku Frimpon. Have a good evening. We'll come your way again, same time next week.